Good day, Crime Talk aficionados. It is Sunday, and we have the weekly recap for the week of May 19th, 2025. All of the top stories throughout the week located in one convenient location. That's right here. You are welcome. Enjoy the long Memorial Day weekend, and we'll see you Tuesday. Remember, the Constitution matters.
All right, lawyer.
Next on the docket, the challenges of a not guilty by reason of insanity defense in regards to the case of Sheriff Mickey Steins. That's right. The not guilty by reason of insanity defense, or NGRI defense, is a legal strategy that seeks to absolve defendants of criminal responsibility due to a mental disorder, impairing their ability to understand their actions or distinguish from right from wrong. Now, while rooted in the principles of fairness, the defense is rarely successful due to stringent legal standards, evidentiary burdens, and basically skepticism of the defense. Now, the case of former Letcher County Sheriff Sean Mickey Steins, charged with the murder of District Judge Kevin Mullins back in September of 2024, well, it kind of exemplifies these challenges. The NGRI defense difficulties is highlighted through the legal, procedural, and contextual factors that diminish its likelihood of success. All right. The NGRI defense typically relies on tests like the McNaughton rule, which requires that a defendant, due to a mental disease or defect, was unable to understand the nature of their act or distinguish right from wrong. In Kentucky, where Steins faces charges, the standard imposes a high bar. Steins' attorney, Jeremy Bartley, claims his client suffered from a mental condition possibly linked to encephalitis, which causes episodes of dizziness, sweating, headaches, and memory loss. However, the surveillance footage showing Steins firing 8 shots at Mullins, some after the judge fell, suggests a level of intentionality that might conflict with claims of his cognitive impairment. So proving that Steins' conditions rendered him incapable of understanding the wrongfulness of his actions is a formidable challenge indeed, consistent with the broader difficulty of meeting the NGRI criteria. So in most jurisdictions, including Kentucky, the defense must prove insanity by clear and convincing evidence. A rigorous standard, right? That's just right below proof beyond a reasonable doubt. And Steins' defense plans to present expert testimony from a psychologist or a psychiatrist to argue that the mental disease or defect or extreme emotional disturbance influenced his actions. Yet the prosecution requests for a state-ordered mental evaluation introduces the possibility of conflicting experts' opinion, which is quite common in NGRI cases. Now, the subjective nature of mental state assessments, combined with the need to pinpoint Steins' condition at the moment of the shooting, underscores the evidentiary hurdles inherent in this defense. Then, let's get real. There's a lot of public and judicial skepticism significantly undermines the NGRI pleas, particularly in high-profile cases like we got in Steins. The Whiteburg, Kentucky community, where Steins and Mullins were longtime friends, was obviously shocked and shooting, and then you got the video, and it's going to reinforce the perception of premeditation, making it a little difficult for jurors to accept a possible insanity defense. Now, prosecutors are often skepticism, noting that, for example, like in Steins' case, the post-shooting statements, such as claiming that his family was in danger, suggests awareness of actions potentially indicating he knew right from wrong. And this aligns with the broader societal resistance of NGRI, fueled by the defendants evading accountability. Like I said, the insanity defense typically requires a severe mental disease or defect, such as schizophrenia, excluding conditions like temporary emotional distress or personality disorder. Steins' defense cites stress from a recent deposition in a lawsuit alleging sexual misconduct by a deputy in Mullins Chambers, alongside reported symptoms of this encephalitis. Now, while these factors may have caused distress, they may not meet the threshold for a qualifying mental disorder. Anyway, the defense's emphasis on extreme emotional disturbance as a secondary strategy suggests an acknowledgement that insanity may be difficult to prove, as the partial defense could reduce the charge to maybe manslaughter. Now, let's just say hypothetically that old Mickey Steins is successful and he gets a not guilty by reason of insanity verdict. Does he walk free? No. Like most places, no. You're going off to the loony bin. That's right. Steins would likely face indefinite commitment to a psychiatric facility subject to periodic evaluations. So that prospect, coupled with the stigma of an insanity label, may deter a lot of defendants from pursuing the defense. And in Stein's case, the possibility of lengthy hospitalization may not be viewed as a favorable outcome, particularly given the public's scrutiny and the severity of the crime. Now, Stein's defense hinges on 5-hour deposition on September 16th of 2024 in a lawsuit accusing him of failing to supervise a deputy who allegedly coerced a woman into sexual acts in Mullins Chambers. If that would cause such emotional distress, I can't believe we gave this guy a gun to be the sheriff. So the defense also has the narrative of paranoia and emotional disturbance, and it aims to frame Stein's action as a mental break rather than a premeditated act. But the prosecution has to counter that shooting that reflects the rage, retribution, supported by the deliberate nature of the video. So the NGRI defense is used in less than 1% of all felony cases, with a success rate of between 10 to 25% in those instances. Stein's case, with its clear video evidence and lack of documentary history of severe mental illness, faces significant obstacles. The inclusion of the extreme emotional disturbance as a fallback defense may be a strategic move to secure a lesser conviction, as it requires a lower threshold than insanity. However, NGRI carries risks, as jurors may impose a harsher sentence if they perceive the defense as attempting to avoid responsibility. Yeah, there you go, ladies and gentlemen. Stein's, it's on video, for God's sakes, man. Maybe go for some sort of heat of passion or something, right? But, the stress of the job, a deposition, oh my gosh, if stress of the job was a free pass for homicide, most attorneys would be knocking people off everywhere you go. It's just kind of a little NGRI, right? No, step up like a man, plead guilty. It's second-degree murder. Take the deal. You killed the judge, man. And we thought there was going to be something, good about it. Nothing has materialized. That's why you got to be so skeptical of a lot of the speculation out there on cases. All right, ladies and gentlemen, let me also continue on the Kohberger matter. So yesterday I was reviewing comments as I was enjoying a fine cigar. And one of these comments stuck out. It's from a Deborah Higginbottom, I believe. And it says, "I have too many questions. How can one have no motive, no criminal background, no knowledge of the victims, no stalking per the state attorney Thompson, no knowledge of the home, no dexterity with knives per past employment, be a crime iCloud forensic doctoral student, and drive your own car and carry a cell phone to a crime, let alone parking a few feet away and entering a dark unknown house with 5 cars, 6 people, barking dog, and do a crime in minutes, plus clean up all while holding a knife and using different weapons, techniques, and weapons. And how about this? He was a vegan, hated blood and meat, and wouldn't even want to eat food that was cooked with meat juices, and I do not believe he wants to be covered in blood. No DNA was found in his car, home, or office. Mention the sheath. No one else thinks it's weird that it was found underneath Madison Mogen's blanket when they reported last week that there was no resistance from MM, who was likely passed out or sleeping. This means BK would have to fight 3 young, strong adults while holding a slippery knife and still manage to kill them. And what about Dylan not mentioning that he should be panting hard while holding a bloody knife, but she also saw his eyebrows? We won't mention the 8-hour delay, crime scene cleanup, the questionable trace DNA on a brass button for a day, and no IDing BK from Dylan. How many more things equal reasonable doubt? Let the trial play out. People need to see both sides. I agree. The trial will have to play out. But let's kind of go through a little bit of this, all right? And, let's kind of respond to it. And like I said, we know what the evidence is that's been released. There's a lot of stuff we don't understand. But this was my kind of general response to this. I understand your concerns about the Bryan Kohberger case. There are indeed many questions surrounding the evidence and timeline. Let's kind of break it down logically. Now, the lack of clear motive, criminal background, or direct connection to the victims does raise questions, but it's not uncommon in some cases for or the elements to be unclear initially. The prosecution might be relying on circumstantial evidence like the cell phone pings near the crime scene, the white car, and the knife sheath with Kohberger's DNA. While no other DNA was found in his car, home, or office, the sheath's DNA is a significant piece of evidence tying him to the scene. It is possible the sheath was overlooked during the chaotic nature of the events. The vegan detail and the absence of blood or meat consumption might suggest he took precautions to avoid leaving biological evidence, though this is obviously somewhat speculative. The lack of resistance from the victims could indicate they were caught off guard, possibly asleep, which aligns with the early morning timing. Kohberger, as a criminology student, might have had the knowledge to minimize evidence, though the 8-hour delay in crime scene cleanup concerns are valid. Trace DNA, like on the brass button, can persist despite cleaning attempts. Now, Dillon limited the description, and the absence of more direct identification are puzzling, but trauma can affect memory and perception. As for the physical challenge of the overpowering multiple victims, a surprise attack with a knife could explain this, especially if the victims were not fully alert. This case isn't airtight, and doubts highlight gaps that the defense might explore at trial. Both sides will be heard to get to clean up the picture, so to speak. So let's see how the evidence holds up in court. That was my response. But I think it's valid. Listen, we all do not have complete and total access to the all the evidence in this case. Frankly, I hope the case doesn't result in a guilty plea, if one is even extended to Mr. Kohberger. But if he wants to exercise his constitutional rights to proceed to trial, then he should be allowed to do that and let the world see, just like Judge Hippler has said, this needs to be televised. It needs to be open to the public. So regardless of whatever the decision is, people can say, yes, I understand how the jury reached that verdict. But I just thought that was kind of, I get lots of people that say, oh, Bryan Kohberger, is completely innocent. There's too much doubt, etc. And yes, it can all be explained away, just like you can say, well, this is enough to raise reasonable doubt. This is enough to raise reasonable doubt. Well, we'll just have to wait and see if it is enough to raise reasonable doubt, or whether the government will be able to carry their burden of proving each and every element of the offense beyond a reasonable doubt. Another secret hearing in the Bryan Kohberger matter. That's right, ladies and gentlemen. There's been a secret hearing scheduled today in the Bryan Kohberger matter. And I guess it's really not too secret because we got notice that there was a hearing. We just weren't invited to attend. That's right. The sealed discussion regarding, quote, the role of the victims will be conducted via Zoom today. It was actually already conducted at 11 o'clock. And obviously, given the limited public information and the sealed nature of the hearing, the exact purpose can only be inferred based upon the case context and the standard legal practices, obviously, in a high-profile criminal case, particularly those involving victims of violent crimes. Now, let's do a little bit of analysis. Now, for those who don't know, Bryan Kohberger is charged with 4 counts of first-degree murder and 1 count of felony burglary in connection with the November 13th, 2022 stabbing deaths of 4 Idaho students, for example, or that include Madison Mogan, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin. Now, the trial is currently set to begin on August 11th of 2025 there in Ada County in Idaho. The trial is expected to last 3 months, and if Bryan Kohberger is found guilty, the prosecutors at this time intend to seek the death penalty. Now, obviously, this case has a lot of public attention that led to a gag order limiting public statements by parties involved in this particular case. And there are multiple sealed filings to protect the integrity of the proceedings. Now, the Judge Hippler, has been presiding over the pretrial hearings, and he's been addressing evidence, admissibility issues, trial logistics, and other procedural matters. Now, the potential purpose of this hearing, the role of the victims, that's always an interesting one. Well, the role of the victims, the phrase role of the victim suggests that the hearing will address legal, procedural, and logistical matters concerning the victims' families, surviving roommates, or other individuals impacted by the crime. Now, given the sealed nature of the hearing and its occurrence via Zoom, it likely involves sensitive and confidential issues that require privacy to prevent prejudicing the trial or violating the gag order. Now, here are, possible likely topics covered. First, Could it be victim impact statements and sentencing considerations? The hearing might discuss protocols for victim impact statements, which are obviously presented after the trial is concluded and the sentencing phase if the defendant is convicted. Now, in a potential death penalty case like Kohberger, victim impact statements from the victim's family or friends could play a significant role in the jury's consideration of whether to impose the death penalty or life imprisonment without parole. Now, the court may need to clarify how and when these statements will be submitted, whether they will be presented in person or in writing, and any limitations to ensure compliance with the appropriate legal standards, right? To avoid a mistrial. The sealed nature suggests discussions about sensitive personal data concerning public disclosure, right? Then we have the Victims' Rights Act under the Idaho law that grants crime victims specific rights, including the right to be notified of court proceedings, to be heard at certain stages of the proceeding, and to be treated with dignity and respect. The hearing could address how these rights will be implemented, particularly for the victims' families or surviving roommates who may obviously testify and want to attend the trial. For example, the court might discuss accommodations for the victim's family in the courtroom, the right to confer with the prosecutors, or the protection against media harassment. The sealed status could indicate discussions about specific families' requests or conflicts, such as ensuring their safety or privacy. Then, obviously, the potential issue regarding the surviving roommates. The two surviving roommates were present, obviously, in the house during the murders, of whom Dylan Mortensen reported seeing the masked intruder with bushy eyebrows. Now, this testimony is expected to be critical, and prosecutors have requested that the live stream be shut down during their testimony to protect their privacy, with only audio permitted. The hearing could also then focus on the role of the roommates as both witnesses and victims, addressing logistic details like, for example, how will they be shielded from the public exposure, their emotional or psychological readiness to testify, or defense challenges to their credibility. Now, the defense has argued that Mortensen's account is unreliable due to being intoxicated and possible, exposure to media. But the sealed hearing would be appropriate to discuss their personal circumstances and safety concerns as well. Now, obviously, this case has been subject to intense media scrutiny, prompting the judge to issue these gag orders governing courtroom conduct, as well as decorum orders, including restrictions on filming, and obviously the gag order to try and prevent leaks. Now, there's, as we've talked about, been some recent releases of information that has not necessarily been made public, and it's a leak. And that leak made it to Dateline NBC's episode that disclosed previously undisclosed information about the case. Now, the hearing might address how the victims' families or surviving roommates will be protected from the media's intrusion at trial. This could also include discussions about sealing certain filings, limiting public access to victims-related testimony, or even managing courtroom seating to prioritize victims' family. Now, like I said, the sealed Zoom meeting suggests a need to discuss these measures privately to avoid tipping off the media or the public. Now, there could also, and probably less likely, the hearing could touch on the victim's family's input regarding any potential plea deal, as Idaho law allows victims to be heard on plea agreements. Now, Judge Hippler has previously directed the defense to provide a declaration by late June or early July regarding any plea offer from the prosecutors as well. Now, if prosecutors are considering a plea to avoid the death penalty, the victims' families might be consulted and their perspectives could be discussed in a sealed setting to maintain confidentiality and to comply with the gag order. However, there is no public indication that a plea deal is actively being negotiated. There's always that possibility. Now, the defense has repeatedly raised the possibility of an alternate perpetrator submitting a sealed offer of proof and facing a May 23rd deadline of providing that proof. A hearing has been set for that on June 18th, and that may also, be discussed. So the role of the victims' hearings could indirectly relate to the defense strategy, such as, like I said, discussions of whether victim-related evidence supports or contradicts the alternate perpetrator theory, and the sealed nature would align with protecting sensitive investigative details and witness identities. So maybe we'll get an order from the court stating what the sealed hearing was about, and if it comes out in the order what the nature of the hearing was about, guess what? I guess it didn't need to really be sealed now, did it? Once again, all these matters should be made public, in my humble opinion. I've never seen anything like this in any courtroom that I've appeared in, and I've appeared in courtrooms across the country where so much is done in secret and privacy. And I think it totally goes against the public's right to know. I appreciate Judge Hippler's efforts to protect the integrity of the proceedings, and has obviously been more forthright and forthcoming with information about this case, and particularly the motions and orders. But like I said, you could walk into any courtroom just about anywhere else, and you could hear the most sensitive, revealing things that most people don't want to hear, because it's called a public courtroom. And you can walk in and just do that. And just because this is a high-profile case, I don't think it gets special treatment. Let me know what you think, and hopefully we'll find out what the secret meeting is about. Next on the docket, an update on the Sean Combs case. That's right, the 9th day for the Sean Diddy Combs federal sex trafficking and racketeering trial featured testimony from rapper Kid Cudi, however you pronounce it, I don't know, Cudi, former assistant George Kaplan, makeup artist Mila Morales, and hotel manager Frederic Zamor. The prosecution is obviously trying to prove that Combs led a criminal enterprise involving coercion, violence, drug-fueled freak-offs, while Combs denies the charges, with his defense admitting to domestic violence, but contesting the trafficking and racketeering allegations. So the rapper Kid Cudi, whose actual name is Scott Mescudi, Mescudi, dated Cassandra Cassie Ventura briefly in 2011 during a period she claims that she was on a break from their relationships with Mr. Combs. Anyway, so the ex-boyfriend back in 2011 received a panic call from Ms. Ventura. Ventura called him and sounding stressed, nervous, scared, alleging Combs learned of their relationship and demanded his address, the boyfriend's address. Cudi took her to the Sunset Marquis Hotel for safety. Mr. Cudi testified that Combs' assistant, Capricorn Clark, called him claiming Combs and the associates were at the Hollywood Hills home. And Cudi found open gifts, his dog locked in the bathroom, and Chanel items disturbed, though the front door was unlocked. And then there was an incident of a car arson in January of 2012. Mr. Cudi's Porsche was set ablaze with a Molotov cocktail. He suspected Combs' involvement, showing jury images of the damaged vehicle. No direct evidence linked Combs, and DNA evidence pointed to a female, actually. Anyway, the rapper met Combs at the Soho house, described his calm demeanor as off-putting, and likening him to a Marvel supervillain. Combs denied knowledge of the car fire when he was confronted about it on cross-examination. The defense attorney suggested that Ventura misled Mr. Cudi about their relationships with Combs, to which Cudi agreed both were played by Ventura, who continued freak-offs with Mr. Combs. Now, the question is, does this bolster the prosecution's narrative of Combs' alleged violent retaliation against romantic rivals? Though there's a lack of direct evidence weakens, obviously, the arson claim. Then they heard from George Kaplan, a former personal assistant between the years of 2013 and 2015. Anyway, he worked for Combs and witnessed quite a bit of abuse. Specifically, back in 2015 on a private jet, Kaplan saw Combs standing over Ventura, who was on her back, her legs raised after a glass shattered. Ventura screamed, "Isn't anybody seeing this?" Kaplan did not intervene, he said, citing, his career aspirations. There was also the abuse of a woman by the name of Gina Hun. Back in 2015, Kaplan witnessed Combs throwing apples hard at Miss Hun, who shielded herself, and Kaplan left and later quit, uncomfortable with Mr. Combs' behavior. Kaplan cleaned hotel rooms up for Mr. Combs. after freak-offs disposing of alcohol bottles, baby oil, and drugs to protect Mr. Combs' image. Rooms were booked under aliases like Frank Black. He bought MDMA and an unknown substance for Mr. Combs. But he did praise Combs for teaching work ethic and still wished him well, but quit after all of the abuse that he witnessed. Obviously supports the allegations of pattern of violence and the cover-up of the operations, Mr. Combs. Then we heard from Mila Morales, a makeup artist, worked with Miss Ventura, considering her a little sister. At the Beverly Hills Hotel back in 2010, Morales heard Combs angrily enter, demanding Ventura's whereabouts. After hearing yelling and screaming behind a closed bedroom door, Ventura emerged with a swollen eye, busted lip, and a knot on her head. On cross-examination, the defense noted that Morales only heard, not saw, the incident and highlighted her media appearances, suggesting bias. Ms. Morales confirmed receiving $1,000 for some photos. But once again, it does provide some eyewitness corroboration of Ventura's abuse. Allegations, though limited to people just hearing it. Then we heard from Frederick Zamore, the Beverly Hills general manager, where Combs frequently stayed. Combs used aliases like Frank White and Frank Black to for stays linked to freak-offs. And the guest's profile noted excessive oil and candle wax requiring deep cleaning and a $1,000 damage pre-authorization. Staff were instructed to set rooms at 75 degrees, stock fruit and chocolate, and use a lot of air fresheners. Kind of corroborates Ms. Ventura's testimony about the nature and the aliases used for Combs' hotel-based activities. Anyway, Thursday's testimony painted a vivid picture of alleged abuse, coercion, and cover-ups within Combs' orbit. And rapper Cootie's account of burglary and car arson, Kaplan's description of violence and cleanup duties, Morales' recollections of Ventura's injuries, and Zamore's hotel records collectively support the prosecution's case of the criminal enterprise. The defense, however, challenged witnesses' credibility and framed Ventura as manipulative, aiming to distance Combs' admitted domestic violence from the trafficking and racketeering charges. The trial continues to unfold, and we'll see where things go tomorrow and next week. Next, a tragic shooting at the Capitol Jewish Museum claims the lives of a young diplomatic couple. That's right. A devastating shooting outside of the Capitol Jewish Museum on Wednesday evening, May 21st, claimed the lives of Yaron Leshinsky, an Israeli citizen, and Sarah Lynn Milgram, an American citizen. Now, the young couple, described as being on the verge of engagement. Apparently, the big proposal was going to come this weekend, if you can imagine that. Anyway, the couple was gunned down as they left a young diplomat's event at the museum. Now, the suspected shooter is Elias Rodriguez. He's a 31-year-old man, and he was arrested shortly after the incident and now faces multiple murder charges, including the murder with the possibility of the death penalty. Now, according to the affidavit written by the FBI, surveillance footage captured the chilling details of the attack. Rodriguez, who had purchased a ticket to the event just 3 hours prior, approached the couple as they prepared to cross the street. According to the arrest affidavit, Rodriguez walked past Leshinsky and Milgram, turned to face their backs, and drew a firearm from his waistband. Extending both arms, he fired multiple shots as evidenced by muzzle flashes, and after the couple fell to the ground, Rodriguez advanced closer, leaned over them, and continued firing. The affidavit notes that Milgram, referred to as Decedent One, attempted to crawl away. Rodriguez followed her and fired again. He appeared to reload his weapon before shooting Milgram several more times. In total, he fired 21 shots, ladies and gentlemen. Now, Mr. Rodriguez, a Chicago resident, had flown to Washington, D.C. on May 20th, 2025, with a firearm in his checked baggage, which he had legally declared with the airlines. After the shooting, he had been seen on video jogging back towards the museum entrance, where he discarded his weapon and, after it stopped shooting and firing, obviously, mistakenly assumed to be a victim. Rodriguez was allowed inside the museum by security guards. There, he he reportedly told police, "I did it for Palestine. I did it for Gaza. I'm unarmed." Following his arrest, Rodriguez waived his Miranda rights and expressed admiration for Aaron Bushnell, who set himself on fire in front of the Israeli embassy in 2024, calling him a courageous and a martyr. The event at the Capitol Jewish Museum was a private gathering for young Jewish professionals aged 22 to 45, with the location undisclosed publicly due to security concerns. Attendees were required to purchase tickets to access the venue's address, and the shooting has sent obviously shockwaves through that community, with protesters gathering outside the museum and investigators remaining on the scene into Thursday to process evidence. Now, Rodriguez, who appeared in federal court in Washington, D.C. on Thursday, faces 5 charges: murder of foreign officials, causing death through firearm discharge, discharge of a firearm during a crime of violence, and 2 counts of first-degree murder. The judge informed Mr. Rodriguez that convictions on the first 2 charges could result in the death penalty, and while the other charges carry potential life sentences as well. Now, during the hearing, Rodriguez, dressed in a white prison jumpsuit and unrestrained by handcuffs, remained calm, nodding as the charges were read and briefly smiling as the matters were set for future proceedings. Now, Rodriguez is being described as a far-left activist, previously worked for an oral history research for the History Makers, a nonprofit focused on African-American communities. His work profile has since been removed from the organization's website, described his role as a preparing research outlines and biographies accomplished African-American leaders. Rodriguez was also affiliated with the Party for the Socialism and Liberation, the PSL, though the group issued a statement denying involvement in the shooting, saying Elias Rodriguez is not a member of the PSL. "We have nothing to do with this shooting and do not support it." Well, guess what? They also found an alleged manifesto attributed to Rodriguez, published online before the attack, criticizing the U.S. government's stance on Israel and claiming public opinion has shifted against the genocidal apartheid state. Surveillance footage also reportedly captured Rodriguez shouting "Free Palestine" after the shooting, and while some pro-Palestinian demonstrators have praised Rodriguez, calling him a hero, the broader community has condemned the violence. So obviously, what we have here, ladies and gentlemen, is a man goes to a location, basically shoots 2 people in the back, repeatedly fires some 21 times. Obviously, these people are now dead. Horrendous acts. People condemn them, right? If that's not murder after deliberation, I don't know what is. But then let's go back to the Luigi Mangione case, right? Man accused of killing the CEO in the back, firing, several shots, killing him, and then fleeing the scene, trying to mix in with the crowd. He's seen as a hero. I don't know. Sometimes you have to be intellectually honest when you evaluate the law, right? Here's the law. Here's the facts. It's not like you're rooting for a sports team, ladies and gentlemen. You have to be intellectually honest. And if the facts are nearly identical and it's being condemned, and then the other case, like the Mangione case, he's being praised as a hero and people are funding his defense with almost $1 million, you got to wonder what's going wrong. Now, this Rodriguez guy, he's screwed. The people that he was out there, acting on their behalf, trying to raise awareness, I wonder what kind of legal defense fund he's going to get raised for him. My guess is it's probably going to be 0, ladies and gentlemen. Something to think about. Something to think about as you go into this long weekend. Am I being intellectually honest? Think about that. That's what the law requires. Calling balls and strikes. And if you always get the result that you want, you're not being intellectually honest. I assure you. But as a defense attorney, you have to be intellectually honest, because if you give the bad advice because you ignore the bad facts and your client goes to prison for longer than he should have because you didn't say this is a bad fact, well, you could be potentially committing malpractice now, couldn't you?